Hello students, welcome to SRIRAM's IAS. Welcome to this class. This is a live class of Indian Polity Current Affairs which is going to help you in your upcoming prelims examination, and we are going to see several current affair topics from last year and from this year, and we are going to study about the static part. Before we start, congratulations to all the people who have made to the final list, who have become officers this year. Today the result of UPSC was declared. Hearty congratulations from SRIRAM's IAS to you all. And let's begin our class. So this is a current affair class presented by me. I am Mayank Bhardwaj. Let us take the first topic. It is about the doctrine of curvature. What is this doctrine of curvature? You know, male and female, they are two different legal entities, isn't it? Every individual have their own dignity. Every individual have their own capacity. Every individual have their own standing. Legal standing also, individual social standing also, economic standing also. भाई आपका आधार कार्ड बनता है तो वो सबकी आइडेंटिटी बताता है ना, वोटर कार्ड बनता है वो हर एक इंडिविजुअल की आइडेंटिटी बताता है. बट दिस डॉक्ट्रिन says that after marriage, the legal identity of a woman was subsumed in the legal identity of a man. Means they both were treated as one legal person. So this is the legal identity of a woman. It was intact before marriage, but after marriage, it was subsumed by the legal identity of a man. Man here is the husband. Now, of course, this is very patriarchal kind of law which was used in England. It is one of the doctrine of the common laws. India follows common law, but India does not follow this particular doctrine. It should not be used, and it is not used because it infringes the fundamental right of individuals here in India. Article 14, right to equality. Women have equal right like men. Article 21, right to life and personal liberty. She has a life. And when I say life, it is the dignified life. It is not some animal existence. Repeatedly told by Supreme Court in several of its orders. Then Article 15 prohibits discrimination on the basis of religion, race, caste, sex, place of birth. So on the basis of gender also you cannot discriminate. So how can you use this particular doctrine in today's India, today's democratic India? It is not possible, but it was in current affairs. It was seen somewhere. Judicial commentary and academic debates have reignited discussions around the archaic doctrine of coverture and its relevance to gender justice. It is not used in India because it infringes upon several articles. So if UPSC asks you in prelims examination, what is this doctrine? I hope you will be able to answer it now. Let's see a little bit about it. It is a British common law, not used in India, and I am pretty much sure it is also not used in Britain now. So it was used in colonial era or before that. A married woman's legal identity is subsumed under her husband's identity. किसी भी महिला को कुछ rights अगर ना देने हो, for example inheritance के rights, लिटिगेशन के राइट्स, तो ये आप डॉक्ट्रिन यूज करवा सकते हैं. ओके, इनहेरिटेंस कैन ओनली हैपन व्हेन a woman has a legal identity of her own, have a social standing of her own. But if her identity is subsumed in that of her husband, how can she be a different person? She is not treated as a different person if this particular doctrine is applied. So I hope you have got the bigger idea of what doctrine of curvature is all about. Let's move to the next topic. This is a different doctrine which is a very useful doctrine, and Supreme Court uses it for positive things, harmonious construction. So there are several provisions of the Constitution. What if two provisions are conflicted? One provision is in conflict with other. For example, there are fundamental rights, and the fundamental rights must not be breached by the actions of the state or by the policies made by the legislature. It's a simple understanding. But what if the state has to implement the directive principles of state policy? And in order to implement the directive principle of state policy, some of the fundamental rights are infringed. Which of the provisions should stand? So to not nullify any of the provision, to not declare one of the provision as redundant and inoperative, Supreme Court uses the doctrine of harmonious construction, that the harmony must be maintained between two provisions. Okay, and both the provision shall not be inoperative but should be working. But if there is any special law, the special law must get priority over the normal law. Okay, so with example we can understand. If let's say this is Article 31C, which sort of a exception, okay, it was added later on, it was not there in the original constitution, it was added later on by different amendments. 31A, 31B, both these were added by the first Constitutional Amendment Act in 1952, and this was added later on in the 25th Constitutional Amendment Act in 1971. What does it say? That if any action is taken by the executive or by the parliament to implement the directive principles of state policy written under Article 39B and 39C, and if there is an infringement of any fundamental right, especially the fundamental right of equality and fundamental right of freedom, Article 14 and Article 19. So if any action of the government while it is trying to implement the directive principle of state policy given under this particular article infringes Article 14 or Article 19, then that infringement shall not stand. That simply means that nobody can move court on the ground that fundamental rights of equality and freedom is breached by the action of the executive or by the law or the policy made by the parliament, when the executive or the parliament are trying to implement the directive principle of state policy given under Article 39B and 39C. 39B, 39C पे थोड़े दिन पहले जजमेंट भी आया था. प्राइवेट प्रॉपर्टी क्या होती है इसके ऊपर, क्या प्राइवेट प्रॉपर्टी को कम्युनिटी की प्रॉपर्टी माना जा सकता है कि नहीं, और अगर माना जा सकता है तो कम्युनिटी की प्रॉपर्टी जो है उसका इक्वल डिस्ट्रीब्यूशन होना चाहिए. So for example, if your property is taken up by the government and is declared as a community property, it will be distributed among all equally. The fruits of that, the resources and all the earnings through that property will be distributed equally. So Supreme Court said that you cannot declare any property as a community property. You cannot take the private property of a person and declare it as a community property. Okay. Of course, there are, properties which belong to a person but have wider national and social use that can be declared as a community property and can be distributed among everybody equally, but not all the private properties. So, I hope you are getting what is harmonious construction. If I am sounding too legal, I am going to make you understand in a very simple language. अगर कोई fundamental right और कोई डायरेक्टिव प्रिंसिपल ऑफ स्टेट पॉलिसी के बीच में कॉन्फ्लिक्ट है, या तो फंडामेंटल राइट इंप्लीमेंट हो सकता है या डायरेक्टिव प्रिंसिपल इंप्लीमेंट हो सकता है, दोनों एक साथ इंप्लीमेंट नहीं हो सकते. देयर इज अ कॉन्फ्लिक्ट. व्हाट इज द स्टेप टू बी टेकन? जो भी चीज स्पेशल है, जो भी चीज वाइडर गुड के लिए है, दैट विल बी गिवन प्रेसिडेंस. इस केस में एक्सप्लिसिटली मेंशन्ड है आर्टिकल 31C के अंदर कि किसी भी तरह का कानूनी कार्रवाई नहीं होगा अगर डायरेक्टिव प्रिंसिपल ऑफ स्टेट पॉलिसी को लागू किया जाता है, और सिर्फ वही डायरेक्टिव प्रिंसिपल ऑफ स्टेट पॉलिसी जो आर्टिकल 39 के क्लॉज बी और क्लॉज सी में लिखी हुई है, कोई भी दूसरी डायरेक्टिव प्रिंसिपल नहीं. सो दैट इज व्हाट इज हार्मोनियस कंस्ट्रक्शन. हार्मोनियस कंस्ट्रक्शन सिंपली मीन्स that none of these provision which are conflicting in nature, they are conflicting in nature, isn't it? So none of these provisions will be inoperative. None of them will be redundant. None of them will be declared as null and void. Both will be working together. And there will be harmony between these two provisions. Okay, I hope you got it. Let's move to the next topic. Mission Karma Yogi. So this is the capacity building program of Government of India. Capacity building. किसकी capacity building हो रही है? Civil services की capacity building हो रही है. पहले grade A तक के officers की capacity building हो रही थी services में officers की. अब its scope has been increased and included the mid-level and state bureaucracy also. So what is the basic idea behind this Karma Yogi scheme? To build the capacity, of course, but with what vision? The present government is trying to turn the vision of the bureaucracy from rule-based to role-based. This is something which you should understand. From rule-based to role-based. There are many schemes and policies of the government which are very effective if implemented properly. But the point is that bureaucracy is unable to implement it properly for the reason that there are too many rules and regulation and procedures to be followed. Now, if too many procedures are to be followed, too many rules are to be followed, the soul of that particular policy dies. The implementation is delayed, the implementation is not 100%, and the effectiveness is also not 100%. So what is the meaning of such a policy? You make a policy और वो बस rules or regulations or procedures में ही फंसी रह गई. Just to avoid this shift in vision is there from rule based to role based. Okay, I hope you are getting it. It's a program of the government for capacity building. There are several features such as creation of I got Karma Yogi platform for digital learning. और ऑफिसर सीखेंगे ये सब, ये जनता के लिए नहीं है. Encourages behavioral, functional and domain competencies. अगर आपका environment पे पकड़ बहुत अच्छी है, if you know very deeply about the economical issues, then that competency has to be used by the government. And if you are the officer, let's say you are an IAS officer who has very good grip over the economic subjects, or very good grip over the social aspects, or very good grip over the environmental aspects, then you will be used, your competencies will be used in that particular direction. Okay. Covers all government employees across departments. So it's a very positive move. It is going to improve the efficiency of the governance. आप वो काम करने में आपको फायदा मिलेगा, मौका भी मिलेगा जिसमें आपको इंटरेस्ट है, जिसमें आप अच्छे हैं. गवर्नमेंट भी रिकॉग्नाइज करेगी आपकी कॉम्पिटेंसी and then will allow you to work in that particular department. So it's a long program, and we do not know the details of it, but yeah, it is being implemented by the government of India in its own way. Anchored by the Capacity Building Commission. This is one new commission under PM's HR Council. Prime Minister का Human Resource Council भी है. So you should see this, and it's a homework. Try to find out whether it's a statutory body or not. Government fiat से आया था, या statutory body है, या constitutional body है, ये HR Council क्या है? And similarly कैपेसिटी बिल्डिंग कमीशन, इसका भी आप पता करके बताइए, कमेंट सेक्शन में लिखकर बताना. मूविंग ऑन टू द नेक्स्ट टॉपिक, इंपॉर्टेंट टॉपिक, नेशनल ह्यूमन राइट कमीशन. नेशनल ह्यूमन राइट कमीशन इज अ स्टैट्यूटरी बॉडी इन इंडिया. ओके, इट इज अ वेरी इंपॉर्टेंट बॉडी. इट ट्राइज टू प्रोटेक्ट द ह्यूमन राइट्स इन इंडिया, इट ट्राइज टू प्रमोट द ह्यूमन राइट्स इन इंडिया. बट इसकी जो रैंकिंग है वो अभी गिरा दी गई है. किसने गिराया है? लेट्स सी. There is a global alliance of national human rights institution, Ganhari. It's a global alliance of national human right institution. इसने जो A रैंकिंग दी हुई थी, नेशनल ह्यूमन राइट कमीशन, इंडिया का जो ह्यूमन राइट कमीशन है, उसकी रैंकिंग को नीचे कर दिया है. And why is this happening? Because in a way, if you see, the National Human Rights Commission in India is toothless. It cannot do anything except investigating in human right violations, and after that it just asks the government to do something. So basically there are too many capacity issues with it. There are other issues such as political appointments, inadequate representation of civil societies. There are delays and backlogs in grievance redressal. One more provision is there that if any human right violation has taken place and the reporting of that human right violation takes 1 year or beyond, the National Human Rights Commission is not going to entertain that. So such provisions are sort of making the National Human Rights Commission a toothless body. It is a non-cooperative body. It just sits and it investigates a little. Its findings are also not taken up properly or are implemented. Its recommendations also are not implemented properly. There are too many problems such as political appointment problems, inadequacy in representation, and delays and backlogs. So you must understand that this particular body, National Human Rights Commission, is a statutory body, and it was established in 1983 by National Human Rights, 93 by National Human Rights Act. So there are, if you see the composition of National Human Rights Commission, there's a chairman plus maximum there can be 8 members in this commission. 50% of the people here would be coming from judiciary, plus 50% of the people will be coming from the marginalized societies such as SCs, STs, OBCs, minorities and women. Okay. Moving on to the next topic. 10 states withdraw general consent to CBI to investigate cases. Now, you know India is a quasi-federal state. The federalism issues are in India are many because India is neither perfectly unitary state nor perfectly federal state. Perfectly unitary state like the Great Britain or perfectly federal state like the United States of America. India is somewhere in between. But the power is tilted towards the center. There are many provisions such as the governor who is appointed by the central government, who represents the central government and is also a head of the state government. So there are many provisions in the Constitution of India which sort of makes India a quasi-judicial state. Also the emergency provisions, if you see, it makes the country perfectly unitary when emergency is applied. So now what has happened with CBI? Now Central Bureau of Investigation is a special body in India and special investigating body in India which was established through the Delhi Special Police Act in 1946, and it investigates important cases. Cases which are very high volume, cases which are very important for the socio-economic conditions of the country, and it's a top class investigating agency. Although in past it was also said as a parrot in cage. That is a very derogatory way the terms were used, but that was the truth because the government uses this CBI for its own benefit. Now the same allegations have been put on Enforcement Directorate that the government is using these body against the oppositions. It can be the civil society opposition or can be the political opposition. Okay, anyway, so this body was established under the Delhi Special Police Establishment Act in 1946, and it works as a central agency in several states. So the India is a federal country also, so consent of the states will be required because law and order, investigation, police, everything is there in the state list. But there is a central agency who is going into a state and trying to investigate. So some kind of consent will be required from the state government, isn't it? Now that consent is of two types. One is the blanket consent which is given by everybody to the Central Bureau of Investigation agency, and the other is for the specific cases. But recently what has happened, those consent were withdrawn by 10 states. That we are not allowing the CBI to come and investigate in our states. You look at the context, West Bengal and Punjab have withdrawn general consent for CBI investigation, limiting its operational scope. Now, it's a big news it also shows the failure of efficient working and harmonious working and cooperative federalism. So we often use this word cooperative federalism, but there is no cooperation when it comes to such an important issue such as CBI and its operation in different states. So this is something which we must understand, and it can be a very important issue for your upcoming examination. So Supreme Court in state of West Bengal versus the Committee for Protection of Democratic Rights, this was a case of 2010, has upheld CBI's jurisdiction in court monitored cases, but emphasized federal respect. So federal respect has to be shown. Just because CBI is a very big body, it's a very efficient body, it's a top body for investigation, that does not mean that the federal structure of the country has to be in any or the other way compromised. The consent of the state government is required. The consent has to be taken, and then only the CBI can work. Also those cases which are monitored by the Supreme Court itself. Abhi RG Kar medical college rape case was there. It was monitored by the Supreme Court directly, and also the CBI was monitoring it. Now that is one of the case. In such cases, the operation of CBI is very much valid. But you must understand for your prelims examination, when this CBI was established, what is the composition of the CBI? Is it a constitutional body or not? Is it a statutory body or not? It does become a statutory body because it is established by a statute, by a law brought by the parliament. Okay. It gets its powers from this Delhi Special Police Establishment Act of 1946. Okay. And there are concerns relating to federalism. So a question can be asked and you should be in the position to give the answer. Moving on to the next topic, Lokpal. Now after CBI, another important body, Lokpal. Lokpal and Lokayukt Act was implemented in the year 2013. There was a huge movement in Delhi, Anna Hazare movement, India against corruption movement, and after that the parliament passed the law for the Lokpal and Lokayukt Act, and Lokpal was implemented established as a body at the national level, and Lokpal in different states to investigate into the cases of corruption. So it is a powerful body. In a way, if you see, jurisdiction of Lokpal stretches to Prime Minister. So it can investigate Prime Minister also, to ministers, MPs, Group A and Group B officers. Now you will say that there are no president and governors. We have read yesterday about Article 361, which gives immunity to both president and governor, which is also called as sovereign immunity. And there can not be any kind of cases, either civil or criminal, which can be filed against the president and the governor when they are sitting on their post, when they are serving their tenure. You must understand, Prime Minister comes under the jurisdiction of Lokpal, ministers come, MPs come, Member of Parliaments, Member of Legislative Assemblies, Group A officer, Group B officer. Also the Lokpal can direct the CBI for investigation. It's a very important aspect. And complaints can be made by any citizen, means I or you can go and make a complaint against a particular officer who is a corrupt officer, and you have found out something. You can be a whistleblower in your own department or company or anywhere. You can also go and file corruption charges against the Chief Minister or the Prime Minister. Any citizen of India can file it. Okay, so it's a powerful body. But now what is the problem here? What is happening? If you see, there is lack of appointments, means there are vacancies and the vacancies are not filled. Low case disposal because of lack of appointments. Then insufficient resources, and it is diluting its power. These are the major lacunas which can be seen in the Lokpal Anti-Corruption Act. Okay. And Lokpal was very important when it comes to realizing Article 14 and Article 21 of the Constitution. Right to life and personal liberty, dignified life, you must have a good governance around you. The government which is taking care of its citizen must not be corrupt, at least should not be corrupt. And for that reason, the Lokpal Anti-Corruption Act was passed. Also, the corruption at the basic level, at the bottom, grassroots level was the big problem. आपको एक बर्थ सर्टिफिकेट बनवाना है, आपको एक डेथ सर्टिफिकेट बनवाना है, आपको टांग दिया जाता था या आपसे रिश्वत ली जाती थी. ठीक है, तो इन सब को कवर अप करने के लिए लोकपाल एंड लोकायुक्त एक्ट वाज पास्ड. बट नाउ इफ यू सी lack of appointment, low case disposal and insufficient resources, it tells the story of what is happening with this Lokpal Act. So moving on to the next topic, before that you must understand that statutory body Lokpal and Lokayukt Act of 2013. यहाँ से आई है, you must understand, it's a very important body. Supreme Court in a majority verdict upholds constitutional validity of EWS quota. Now EWS quota is for the general classes. So we have several classes, isn't it? Scheduled castes, scheduled tribes, other backward classes, socially and educationally backward classes, and there is general class. Okay, so the poor people of general class, or the people of general class who are not economically sound or were economically weaker, were given 10% quota in employment and in educational institution. Okay, so this EWS quota was extended to the general class. So petition was filed in the Supreme Court, and it was said that this particular EWS quota must also be extended to scheduled caste, scheduled tribes and OBC. And if it is not extended to these classes, it infringes the basic structure of the Constitution. Supreme Court in its judgment said that not extending EWS quota to scheduled caste, scheduled tribe or OBC does not infringe the basic structure of the Constitution. Okay, it's a very important provision which you should understand, that EWS quota is applied to general category, 10% of reservation which is over and above of 49.5% reservation, which is extended for SCs, STs and OBCs. OBC get 27%, ST get 7.5% and SCs get 15% in employment and in education. Where is the provision? EWS. If you see article number 15, clause number 6. Okay, article 15 prohibits discrimination on several grounds, on the grounds of religion, race, caste, sex, place of birth. But there are several exceptions also. Special provisions can be made for other backward classes, for economically and for socially and educationally backward classes. Special status, special provisions can be made for women and children. Special provisions can also be made for SCs and STs. In the similar fashion, special provision of reservation can also be made for economically weaker section in the general classes. And over and above this 49.5%, a 10% reservation is also given. So the 50% limit, the ceiling limit which was fixed by the Supreme Court, people think that 50% ceiling by the Supreme Court was done for all the kind of reservation, but that's not true. 15% ceiling limit is only for the reservation which are extended to SCs, STs and OBCs. This is only for 15 clause 4 and 16 clause 4. 15% limit is not there for EWS, and EWS holds legal sanctity. Article 15 clause number 6 gives it the legal backing. So EWS, it is very much constitutional. That is what the Supreme Court has said. And even if it is not extended to SCs, STs and OBCs, it is not the violation of basic structure. Moving on to the next important topic, need of the hour. What is the need of the hour? Is to raise OBC category creamy layer income limit. Now this was also a case. Something was there in the current affairs section, you know about the Indira Shawni case, and through Indira Shawni case, subcategorization of the OBC was allowed. Also, a creamy layer concept was introduced. What is this creamy layer concept? That OBCs get 27% of the reservation in education and employment, isn't it? Out of these 27% reservation and OBC, there are many categories which are socially and educationally and economically well-off communities. They are so much developed that their social standing or their caste has no impact on their way of life. Those are the people who come under creamy layer. And there are some economic provisions made for who can be the person in creamy layer. Anybody who is earning, whose family earning is less than 8 lakh rupee, this is the person which should not be. No, this was the provision for EWS. I'm sorry, I've forgotten. Who could be the person in the EWS? EWS. Anybody whose family income is less than 8 lakh rupee. So less than 8 lakh family income. If the family is holding a flat, the area of the flat must not be more than 1000 square feet. That's the second requirement. 1000 square feet and less. And if the family is holding a farm, the area of the farm must not be more than 5 acres. Okay. So this is what EWS category is all about. All the people who fulfill these criteria come under EWS. Now moving on to the creamy layer thing. So this creamy layer is there. And this 27% reservation which is given to the OBC is not given to the people who are there in the creamy layers. Okay. Creamy layer को SCs and STs के लिए भी implement करने के लिए बातें चल रही हैं, but अभी तक implemented नहीं है. But it was implemented by Indira Shawni case. This creamy layer concept was implemented for OBCs, and 27% reservation is not applied to the people who are coming in creamy layer. Now, what is the problem here? Recent court ruling and commissions have reignited the debate on defining and revising the income criteria for OBC, creamy layer. कि इसको बदलो, इसको change करो. So the present income threshold is 8 lakh per annum, okay, subject to revision. And several people are saying that it must be revised. Okay. It's a very important concept under Article 15, clause number 4, which gives the state the power to make special provision for socially and educationally backward classes. Under this, the reservation is extended. 27% of the reservation is extended to the OBC in education and in employment. Similarly, 16, clause number 4. So I hope you have understood this. अभी बातें चल रही हैं. अभी क्रीमी लेयर में कुछ चेंज नहीं किया है. क्रीमी लेयर की डेफिनेशन जो थी वो वही है. Okay, but people are saying that it must be changed. Some change must be brought to the creamy layer definition. What is Article 371? Now everybody have heard about Article 370 and its abrogation by the Jammu and Kashmir Reorganization Act of 2019. Article 371 is a different thing altogether. Article 371, if you see, is the permanent article, permanent feature of the Constitution of India. Whereas Article 370, which was abrogated by the Jammu Kashmir Reorganization Act of 2019, was not the permanent feature. It was a temporary feature. If you see, it was implemented in 1950 by the presidential order. Okay, somewhere in 1950 or 1954 by the presidential order. It was not a permanent feature, but Article 370 is the permanent feature. It gives several special status to several states, especially the northeastern states. It has helped the northeastern state a lot to preserve their culture, to preserve their autonomy, to preserve jobs, everything. This thing has helped. 371 has especially helped the northeastern state. Also to bring them into the mainstream society, Article 371 is very important. So the focus on regional autonomy has brought renewed attention to Article 371. Now Article 371 and its subclauses are there from A to G, and several states are included in it, grants special provision to specific states like Maharashtra, Gujarat, Nagaland, and especially the northeastern state. It protects the indigenous culture, it ensures local job and land rights, and it facilitates equitable development. So this is a very, very important article, you must understand. These provisions uphold cooperative federalism and meant to address historical and regional disparity. Now if there were disparities, of course there were disparities. Okay, the people living in the tribal areas or people living in a particular state, let's say Maharashtra, but there are several pockets where people were not in the mainstream. In order to bring those people into the mainstream, some protection needs to be provided. That protection was provided by Article 371. I hope you are getting it. So that is what happens with Article 371, a special provision for several states, especially the northeastern state. Moving on to the next. So CAA, again in news, not to be implemented in most tribal areas in northeastern state. Citizenship Amendment Act of 2019 was not implemented in the areas of 6th schedule and the areas where inner line permit is required. ILP, inner line permit, is required. So what is this 6th schedule? This is very important for you. The 6th schedule have several states such as Assam, Tripura, Meghalaya, Mizoram, and it also have autonomous bodies, autonomous districts, regional districts. That is the special provision for these 4 states. These 4 states are not covered under the scheduled areas which are there under schedule number 5. These are tribal areas. Governor holds a lot of power here. There are also autonomous districts and regional districts, and they also have judicial power of their own to constitute courts which have the civil and the criminal jurisdictions to help the population to solve their problems of law and order. So they do have this autonomous thing. Why? Again, to protect their culture, to protect their autonomy, to protect their way of life. If they are just mixed in the normal mainstream society, their uniqueness will be diluted. That was the problem with coming of the Britishers in India. If you see, majority of the issues of Britishers against the tribal people, the fights were because of the reason why Britishers used to intrude in these tribal areas and use their resources and exploit their resources, which these people, the tribal people, does not like. So after the commencement of the constitution, and the constitution also carries those provisions which protects their autonomy, which protects their uniqueness. And for that several autonomous districts are made, for that regional councils are made. Autonomous districts, the people, there's a 30 people are there who are elected, and they look after the administration of these districts. Governor again holds a lot much of power. So these councils are constitutionally empowered under Article 244 clause number 2. You must understand this. For the tribal identity to be intact, it has to be implemented. And you must understand this one logic, which is a very simple logic, that CAA of 2019, the amendment which was made to the Citizenship Act. Now, Citizenship Act came in 1955. Provisions were already there from Article 5 to Article number 11 in the Constitution of India. This is part number 2 of the Constitution. But these provision only tells who would be the citizen of India on the commencement of the Constitution. इसमें जितने भी प्रोविजन दिए गए हैं वो सिर्फ यही बताते थे कि 26 जनवरी 1950 को इंडिया का सिटीजन कौन है। उसके बाद की जो भी चीजें थी were left on the parliament, and parliament has came up with the citizenship act of 1955. Now the citizenship act have been amended so many times. It was amended in 1985 also, it was amended in 2002 also, and recently it was amended in 2019 also, to allow the persecuted minorities which does not involve Islamic communities or Muslims from 3 different countries to enter India and get citizenship of India very easily. A sort of fast track citizenship has been given to these communities from 3 countries, Afghanistan, Pakistan and Bangladesh. And this particular amendment does not apply to 6th scheduled areas and inner line permit areas. Should voter ID be linked with Aadhaar? Now Aadhaar is linked with everything. आधार का आपके बैंक अकाउंट से लिंकेज है, आधार का आपके वोटर आईडी से लिंकेज है. It raises some kind of privacy issues. So this is the fight between privacy on one hand and linkages with Aadhaar, the efficiency which government wants to bring on the other hand. Why so many datas are linked? There are concerns of privacy. What if surveillances are there? What if our data is leaked? What if linking of several different ID cards or ID card with bank account can result in some kind of problem? There are many things which can happen. So on one hand, after the Puttaswamy judgment of 2017, which upholded right to privacy and said that right to privacy is the fundamental right, several things have changed in India, and one of them is the linkages of Aadhaar with different things. So in the ruling of Supreme Court, it is said that it is not mandatory to link Aadhaar with your bank account. This is not mandatory. Now what will be mandatory? If you are a beneficiary of a welfare scheme, then you have to give your Aadhaar, then you have to link your Aadhaar. But if you are not a beneficiary of a welfare scheme by government, it is not needed to link your Aadhaar with your bank account. So that is basically what has happened. You must understand what is Aadhaar. It's a 12-digit biometric based identity. It is not a proof of citizenship of India. You must understand. Anybody who is living in India for a particular period of time can get Aadhaar card, and it does not provide citizenship. Citizenship is a different thing altogether. Enables DBT, direct benefit transfer to beneficiaries. Voluntary in nature but functionally mandatory in various services. Now what are these various services? Welfare schemes of the government of India. And after Puttaswamy case, we have already seen it is not mandatory to link your bank accounts and telecom services with Aadhaar, but permissible for welfare schemes. Okay. Article 21, right to privacy on one hand, right to equality on one hand, and governance and efficiency of governance on the other hand. Because linkages of Aadhaar, Trinity, JAM, and linking Aadhaar with bank and linking Aadhaar with telecom services and other things improves the efficiency of governance. But it also raises some privacy concerns. 75th Constitution Day, history and significance of 26th of November 1949, hereby we adopt, enact and give to ourselves this constitution. So the Constitution of India was adopted and enacted on this day. It was adopted by the Constituent Assembly. Enacted means it was passed as a law by the Constituent Assembly. And the preamble starts with we the people. And the last it says we give this constitution to ourselves. So to celebrate 26th of November 1949, we celebrate it as Constitution Day, and this was the 75th Constitution Day. Constitution is something which is holding this country together. It is based on the principle of constitutionalism, which means limited government. Okay. Supreme Court also has been coming up with judgment which is stretching the civil liberties in all the areas. If you see the mammoth shape which Article 21 has taken, Those are very important provisions of the constitution. And on this 75th day, Constitution Day, what is important for us in this particular article? What is really important for us is to understand the preamble very, very, very closely. What has happened on which date? What has happened on 26th of January 1950? What has happened on 26th of November 1949? When was the Constituent Assembly started working? When was the Constituent Assembly ended its work? When was the national flag and national anthem were adopted? All these historical dates you must remember. And at the same time, you must also see the special features of the Constitution of India which are not found anywhere. If you see, where will you see the basic structure doctrine? It's not found anywhere. Where would you see the preventive detention? It has been included in the fundamental rights. It is not used, not in United States, not in the Great Britain, in the way it can be used by the government in India. So it's one of the special features, the basic structure, the quasi-federal nature of the Indian Constitution. The fundamental duties, rarely you will find fundamental duties in any constitution around the world. So all these special features of the Constitution of India which is not found anywhere, you must remember this. Maybe UPSC can ask this because it is the 75th Constitution Day. You must remember the dates as well. What are the issues around delimitation? Now, there are several issues around delimitation. We are going to see what. Delimitation Commission and electoral justice. Now, this delimitation commission is there. Must be constituted by the government after every 10 years. This is what the provision is. Article number 82 is involved. So, what is the purpose of establishment of the delimitation commission? To redraw the boundary of the constituencies. So, there are boundaries in India. We have a parliamentary form of government. We all know that we go and cast our votes. That is how the member of parliament are elected and the member of legislative assemblies are elected. Okay, the member of parliament does have a jurisdiction, and then somebody who is a member of parliament of other jurisdiction does not interfere in this jurisdiction. So there is a boundary that people of that particular constituency will go and vote for different people. So I hope I am making sense here. If this is the state, it is divided in several constituencies. Okay, there can be many constituencies within the state. Similarly, if this is a big country like India, it is also divided in different constituencies. So people living in that constituency or are registered in the electoral roll of that constituency go and vote for the particular person who are standing for the elections. Now this number of constituencies which are there, it was done on the basis of 1971 census for states and for national level also. And then in 1971, the next commission came in 2002, and this delimitation commission has fixed or freezed the number of constituencies which were already there at that time till 2026. Now we are in 2025 and 2026 is coming. So it becomes mandatory to establish a delimitation commission which is going to redefine the boundaries, and the boundaries are redefined on the basis of population. आपको थोड़ा और सरल करके अगर मैं बताऊं तो मान लीजिए ये एक कॉन्स्टिट्यूएंसी है, इधर पहले 15 लाख लोग होते थे. ओके, बट अब इस कॉन्स्टिट्यूएंसी में 25 लाख लोग हो गए हैं बिकॉज पॉपुलेशन बढ़ गई है. 25 lakh people are there. So don't you think these must be redefined? That one person was representing 15 lakh people is now representing 25 lakh people. And population increase is not same everywhere. In India also, if you see the southern state for implementation of the family planning and other things, the southern state are at loss. This is one of the important thing or important criticism which is coming out from the Delimitation Commission exercise. That the representation of the southern state in the Lok Sabha is going to decrease. And the reason for that would be the less population rate of the southern state. Because the population increase of the northern state is far higher. The state of Uttar Pradesh, according to the present calculation, would get seats more than 140 seats. Presently it has 80 seats in the Lok Sabha. So if the delimitation exercise is based only on the population, if the present formula is used, then the northern state will get more representation in Lok Sabha, whereas the southern state will be at loss. This is one of the controversy. Also controversy is coming from the northeastern state. That because of the delimitation exercises, several tribal groups have been excluded or included, which is disturbing the balance. So there are too many things and too many problems related to the delimitation commission. So the formula needs to be changed, or the seats will be further freezed for another decade or 2 decades, like it was done in 2002, and the seats were freezed, number of constituencies were freezed till 2026. It is yet to come. The information is yet to come. Government has not taken any decision on what the delimitation commission is going to do, and what will be the recommendation of these delimitation commission, and what will be the formula on which the delimitation commission is going to redraw its boundaries. The boundaries of the constituencies of member of legislative assemblies and the member of parliament. So basically it was dependent on population. There can be other reasons also. Now other criteria can be included. Okay. EVM and VVPAT case. What are the key takeaways from the Supreme Court's verdict? So this VVPAT, why was this implemented? In order to check whether the EVM machine is working properly or not. That was the basic idea behind this VVPAT thing. There was a physical verification by VVPAT that it was a verified slip, voter verifiable paper audit trial. That simply means if you will go to cast your vote, आप बूथ में गए, आपने अपना वोट कास्ट करा, जिस भी पार्टी को आपने वोट दिया ईवीएम मशीन में, साथ में एक स्लिप निकलेगी, और अगर उस स्लिप में उस ही पार्टी का नाम है जिसको आपने वोट दिया ईवीएम मशीन पे, that simply means that EVM machine is working properly. Just to see whether the EVM machine works properly or not, this VVPAT was introduced. This was a way to shut those voices who were questioning the EVM machine, Now, it was implemented on one booth in one constituency. So in one constituency, it was implemented in one booth. That one particular booth would be taken, and this VVPAT thing, this verification will be done in that particular booth. अगर उस booth पर आपका electoral roll में नाम है, that simply means you will go and cast your vote, and also you will get a slip. It will be physical verification of whether the machine is working properly or not. There were concerns, and this one booth was increased to 5 booths. That simply means this VVPAT verification will be done on 5 booths in one constituency. This happened after the 2013 judgment of the Supreme Court in Subramaniam Swamy versus Election Commission of India. Now several people are saying that 5 booths in one constituency constitutes only 1% of votes. Hence, this VVPAT exercise must be implemented throughout the country. Supreme Court said that it's not possible. How can it be implemented throughout the country? There are several concerns. The election will be delayed. Election mechanism will be disturbed. At the same time, there is no capacity to do this. huge risks has to be taken. And there can be other kind of problems as well. So Supreme Court turned down this particular request made that the VVPAT should be implemented throughout the country, and hence it was in news. You must understand the basic ideas behind it. So it brings transparency in voting process. It makes the voting process independent, and the capability to audit the election process becomes very simple, and it reduces electoral fraud perception. But to implement it on a nationwide level or a statewide level would be a bigger problem for Election Commission and for the government. Moving on to the next important thing. Delaying local body polls cost Karnataka rupees 2.8 thousand crore. Local body polls. So local body polls simply means the election to the panchayats and municipalities. Now India is a democracy, and after 73rd and 74th Amendment Act, the democracy was taken to the grassroots level. That even in panchayat elections will be there, for municipalities election would be there. And who is the body? Which is the body which is going to conduct these elections? So the State Election Commission became that body under Article 243K and under Article 243ZA. The panchayat and municipal elections were conducted, and this body was constituted. But this body also needs finances. This body also needs different resources. This body also needs capacity building, needs people to work for it. And all these things are not happening. So the grassroots election process, the grassroots democracy is suffering. On one hand, Maharashtra government and Punjab government are trying to make Nota, none of the above option, as one of the candidate. That simply means it is going to give more effectiveness to the Nota option, that if the Nota option wins, then a re-election will take place. So on one hand, these kind of ambitious ideas are brought forward by the Maharashtra government and the Punjab government, but at the same time, there are also news that state election commissions are not given appropriate resources to work properly. And this was the news from Karnataka. So, what are the challenges? Interference from state government. The government always interferes. The local level bodies are not working very properly. They're not working in a democratic way it should. Lack of autonomy is there. Lack of infrastructure is there. And delayed election undermining grassroots governance. So all the law which are made for the state elections, means the elections of the municipalities and the elections of the panchayat, are made by the state legislature, and it is the state legislature which is responsible for interfering in this process. Interference in the constitutional body, State Election Commission, interference in the election process, interference in so many other things, and not properly sort of giving resources to this particular body to work and implement the democratic values at the grassroots level. It's an important article for you to understand. 73rd and 74th Amendment it shows sort of failure towards those amendments. Moving on to the next one. Mediation opens door for creative solution. What is this mediation? It's an alternate dispute resolution mechanism. Arbitration, mediation. So in 2023, to make this mediation process more better, more efficient, more voluntary, an act was passed which was called as the Mediation Act. Okay. To formalize the alternate dispute resolution through pre-litigation mediation. The Act institutionalized mediation as a time-bound mechanism. Okay, this is a time-bound mechanism. This is not going to go on forever. There has to be some time limit to it. That if a case has to come to the court in the pre-litigation stage, the parties must go to a mediator. And there are several mediating facilities which are available in different courts. If you go to courts in Delhi, Tis Hazari Court or other courts, you will see those mediation centers there. And this process is totally voluntary. If a person wants to file a case against a party, then it can be done. But the judge always tells to go to the mediating center first. This reduces the burden on the judiciary, reduces the number of cases which are pending. It's a very important process. If followed properly, it followed in a formalized manner, then it is going to reduce the number of cases which are pending in the judiciary, the backlog, the the vacancies and everything. It is going to be of some use. So this act was institutionalized as a time-bound exercise. It's a voluntary exercise and a confidential process that the information is not going to leak. And several key features are also there of this Mediation Act of 2023. That it becomes mandatory pre-litigation mediation. So in several cases, pre-mediation has been made mandatory. Not in murder cases or rape cases, which are cases of high volume, the cognizant matters. Police has to take cognizance. The court has to take cognizance. Those are serious matters. In that, there is no mediation which can happen. That's the crime against the state. That is sort of crime against the society. So a case has to be filed. The mediations are done in PT cases or cases which are not of very high volume, which is not a murder or a homicide or a triple murder or a rape case or things like that. Those do not go into the mediation center. Those are crimes against the state. Those are crime against the society. So it needs to be tried in the court of law, not in the mediation center. But there are many cases, civil matters, smaller criminal matters, family matters, financial matters, which can be solved in mediation center through the alternative dispute resolution mechanism. I hope you are getting this. Establishment of Mediation Council of India. So there was no Mediation Council of India, and now this will be established under this particular act. Recognition of online mediation and enforceability of mediated settlement. So if you see Article 39A, equal access to justice to all, it is going to help. This Mediation Act is going to help. It is also going to reduce the judicial backlog and aligning with the global alternate dispute resolution processes. Fast track courts dispose 94% of the cases of sexual offences. So fast track courts have been established by the government, and it has done phenomenal work. If you see the cases under the POSCO Act or cases relating to rape in section 376 of the IPC were solved by these fast track special courts. Okay, so this is a very important thing which has happened. And these court, what does they do? They reduces the pendency, deliver time bound justice, and enhances the judicial sensitivity to vulnerable groups. So special provisions can be made for women and children under Article 15, also under Article 16. So this is one of the provision to provide them justice, in such a way that the justice is not delayed, and the society should become sensitive towards these vulnerable sections, towards women, towards children, and hence the establishment of fast track special courts, which in a way is very fastly trying to dispose of the cases. The investigation done by the police is also a matter of concern, because the investigation done properly by the police and the forensic helps the judiciary to solve the cases in a more efficient manner. Okay, so this is one of the things about the fast track cases. If it has been asked, so you can give the answer. The Gram Nyayalaya Act of 2008. Now the Gram Nyayalaya Act is also there. What does this do? It is established under the Gram Nyayalaya Act. There are several Gram Nyayalayas which are established. They do have the criminal jurisdiction and the civil jurisdiction. So you see, we have the democracy at the grassroots level, elections for panchayat, elections for municipality. So there must also be a ground level grassroots judiciary, and Gram Nyayalaya is one of that. Gram Nyayalayas are implemented or established or has legal backing under the Gram Nyayalaya Act of 2008. And the aim is very simple: accessible, affordable and swift justice. Jurisdiction, as we have discussed, civil dispute, petty offences. And procedure will be informal, flexible and locally rooted. Now we are trying to understand the system which was prevalent in India before the Britishers came here. The justice system of India was like this only. Gram Nyayalayas were there who could solve the cases in a very informal and flexible manner. Local laws were implemented. Religious laws and social laws were implemented. Customs were also implemented. We have included everything now in the constitution. If you see the definition of law under article number 13, customs are also there, which are included, along with rules, regulations, notifications, ordinances. Customs are also there. So customs, social customs, religious customs, they were the laws which were there already in existence before the coming of the British and before they made the modern legal system in India, which became very expensive for Indians. Sort of it was the failure of the justice system after the Britishers came here. That system which we are continuing till today was not working properly in the initial stages. And today we have learned the lesson and we are trying to implement the Gram Nyayalayas under the Gram Nyayalaya Act. And this is one of the provision which reminds you of what was going on before the Britishers came. There were Gram Nyayalayas. They used to work in an informal way, but they were very impactful. They were very efficient. The justice were delivered immediately by them. Okay, the process is coming back, and thanks to the government for realizing and implementing the Gram Nyayalaya Act. And this was done in 2008. Remember this. This was in news and question can be asked. Demand for inner line permit. Now what is this inner line permit? We already know that Citizenship Amendment Act does not get implemented in the inner line permit areas. So inner line permit is a very simple thing. It's a document, it's a travel document that if you have to travel in several states such as Arunachal Pradesh, such as Nagaland, Mizoram, Manipur, you need that travel document, that inner line permit. Now, why this inner line permit implemented? For the same reason why schedule caste, why 6th schedule and 5th schedules were made. To preserve the autonomy, to preserve the culture. Okay. Preserve culture and integrity and demographic composition. It restricts land and job access to the outsiders. It operates as a tool for internal border control. And in these areas, the Citizenship Amendment Act of 2019 is not implemented. Along with this, in the 6th scheduled areas. You must keep this information in mind. So it derives its legal backing from Bengal Eastern Frontier Regulation Act of 1873. So these are laws which are implemented in several areas in particular states where it is of paramount nature to preserve their local culture, to preserve their uniqueness, to preserve their land, to preserve their jobs, and for that the inner line permit is implemented. Enemy property. Government plans control for public purposes. Now what is this enemy property? Those countries which were at war with India and their nationals who holded some property in India and now they are gone. Now their property is called as the enemy property. So there are two countries which were at war with India, Pakistan and China. So the nationals of these two countries who hold it some property here, for example, a person who was living in let's say Delhi or Lucknow or anywhere and has moved to Pakistan and became the citizen of Pakistan and is now living in Pakistan, what happens to the property he has left back? Now that becomes the enemy property. Who takes the control of that property? It is the government who takes the control, total control. And there was an amendment made to the already existing act. This was the Enemy Property Act of 1968. So all these properties were taken up by the government under this act. There was a change, an amendment was made to this particular act. Now there will be total control of the government. The heir of the person on whose name the property is registered, if the heir comes here and asks the inheritance will not be given because it's an enemy property. So no inheritance will be given. And if that property is taken up by the government can use it for monetization also. So these were the changes made in 2017 through an amendment in the 1968 Act of Enemy Property, that no inheritance right to the legal heirs, wastes entire control with the government and enables monetization. So government is planning and is also planning, not only planning, it's also selling these properties in the open market on the market rate. Those are, too much of land are there. Acres and acres of land of enemy property are there, which can be used and monetized for public good in India. And government is doing it. Now, this is one of the important aspect on which question can be asked. You must pay attention to all the articles. High Court in India reaffirms the need for an individual's right to be forgotten. What is this right to be forgotten? Is it written anywhere in India? In the Indian Constitution? Right to be forgotten forms the part of right to life and personal liberty under Article 21 of the Constitution of India. Think about a situation when a person who was wrongly taken up by the police authorities on several charges and the person did not do anything, and later on it was revealed that the person is not guilty and he has been acquitted. But if you go and search his name on the search engine, you will find his name. And what if the same person goes to a company and asks for a job? The company will be prejudiced, thinking that the person has some criminal record. And there is a possibility that the company may not employ that person. Another situation is when a person went to jail, it was proved that the offense was done by the person and the person has served his term. And then he comes out of the jail. What about then? Will he be given any job? Will he be given a house on rent? Will he be given loan by the bank or not? Now that is the problem with the justice system. If we want the reformative justice system, then after the person has completed his punishment, he should be forgotten. And he should be forgotten from the internet also. That when you go and search the name of the person, you are not going to get any criminal record of that person, because the person was either acquitted by the judiciary or the person has already served his terms. So he should be treated as a normal person. He should not be treated as a criminal for all his life, even after he has completed his term, even after he has completed his punishment. So this issue of right to be forgotten comes up. That when on search engines, the name of the person is searched, all the negative news which are not relevant today, which are of no use today, comes up. And that forms a perception about that person, which hurts his right to life and personal liberty, which hurts his dignified life or his self-respect, which is against Article 21 of the Constitution of India. So it's the right to remove or unlink personal data from online platforms. Though not explicitly codified in Indian law, the courts have read it into Article number 21. And also there is one law, data protection principles, which are given in Data Protection Act of 2010. 23. So what are the challenges? Balancing privacy with the freedom of speech and no unified mechanism for redressal. These are the challenges which are there in the right to be forgotten thing. But you must remember that it is the right of the person under Article 21, and if a question is asked which of the following forms the part of Article number 21, for example, if they give right to privacy, bodily integrity, and right to be forgotten, and they ask which of them forms the part of right to life and personal liberty under Article 21 of the Constitution of India, you must mark all of them. Okay? This is why we are reading this current affairs, because these current affairs are linked with the articles. The current affairs are linked with the static part of the Indian polity. Moving on. Anti-defection law. We all know this is included in 10th schedule of the Constitution of India. Let's see what has happened. Anti-defection law and article number 191. So defection during the general election, it reignited that the debate over the effectiveness of anti-defection law. Anti-defection law was implemented because of the simple reason that in the lure of posts and other benefits, the member of parliament or the member of legislative assembly must not leave their parties and jump onto the other parties. So there were several provisions which were made in the anti-defection law, but there are also some criticism. After the implementation of the 10th schedule, after the implementation of the anti-defection law, it was seen that the party leaders have become too powerful. If let's say you are the member of parliament and you want to dissent from whatever your party stance is, you're not allowed. So what is the meaning here? Okay, you should have the basic freedom to dissent from the view. Maybe you do not hold that the same truth which they are holding, or maybe you do not like the point of view of the party, or you dissent from the point of view of the party, and you just vote in the other direction, or you speak in the parliament in some other direction which is not aligned with the viewpoint of your party. What happens? Anti-defection kicks in and you can be removed from your post. You can be removed as a member of parliament. That has made the party leader very strong. That has made the whip very strong. So these are several criticism of 10th schedule or anti-defection law, that it does not allow the individual member of parliament and the member of legislative assembly to hold his own point of view, which can be against the point of view of the party he is representing. And also there are several provisions, such as the one that voluntary giving up the party membership or voting against the party direction, you can be removed from your post. There is also an exception that if a merger is done by the 2/3 of the party member have merged with the other party, then anti-defection law will not be implemented. Okay. And who is the decision-making authority while taking the decision on defection or any case of anti-defection or removal because of anti-defection? It is the Speaker in the Lok Sabha and the Chairman in the Rajya Sabha. But you must remember, all these anti-defection cases can be judicially reviewed by the court. The person can approach the court and the person can represent himself in the court, keep his own particular opinion, why he did what he did and because of what he has been removed, and the decision can be taken by the court. So judicial review is allowed here. How the Supreme Court clamped down on bulldozer demolition. So this bulldozer demolition is taking place. We are talking about Article 142. Now Article 142 gives the power to Supreme Court to do complete justice. Recently also in one of the case, Article 142 has been invoked by the Supreme Court. Recently, if you have seen the case on Article 200, the power of the governor which was curtailed, that the governor should not hold the bills for too long, and several timelines were made that within 1 month the governor has to give the assent to the bill, and if the bill comes back in the same way or with several changes, then within 3 months the assent has to be given by the governor. Even if the governor is sending that particular bill for the consideration of the president, the whole exercise has to be done within 3 months. This judgment came, you must read about that judgment. Several changes were made in Article 200, but coming back to Article 142, what happened through Article 142? There were 10 legislation on which the governor was sitting, and we are talking about the Tamil Nadu state. The governor of Tamil Nadu was sitting on 10 laws which needs to be assented by him, and he did not assent him and sent it for the consideration of the president. So all these 10 laws were made acts by the Supreme Court using complete justice under Article 142. So this was in news. This has been in news so many times. Court have used it also in the Babri Masjid case. Court have used it in Bhopal gas tragedy case. Then in recent demolition cases also. Okay. Environmental protection cases also in relation to Article 200 also we have already seen here. So it exemplifies judicial creativity, but it also raises separation of power concerns. What is the role of executive? It was the duty of the governor, or if the bill is sent to the consideration of the president, then it was the duty of the president to sign those 10 bills. But they were made act by Article 142 by the Supreme Court. So there were concerns over the breach of separation of power principle. Okay, moving on to the next one. Collegium. Now collegium has been in news so many times. So what is there on collegium? Vacancies in the high courts and delay in appointment revived scrutiny of the collegium system. So what is the basic idea of this collegium system, and why are collegium system implemented? I mean, what does the collegium system do? Collegium system became powerful after the 3 judges cases. Before the 3 judges cases, what used to happen, if you have to transfer a judge or if you have to appoint a judge to the Supreme Court or to the High Court, it was the president who used to appoint it, and the consultation was made by the president from the Chief Justice of India. So the president used to consult the Chief Justice of India before appointing a judge. So it was whole soul the power of the government to appoint a judge into the High Court or to the Supreme Court. But after the 3 judges cases, this word consultation got changed to concurrence. That whatever consultation or whatever recommendation which is provided by the Chief Justice of India for the appointment and transfer of a particular judge has to be followed necessarily and shall be followed by the President of. So all the appointments which were done by the President of India has to be approved by the Chief Justice of India, or in a way the Chief Justice of India through its collegium system was the one who was the most powerful body to make the judges, to appoint the judges. And the government now has no say in it. It is the president who appoints it, but only after the consultation from Chief Justice of India, and that consultation is concurrence. That the consultation has to be followed. The president is bound to follow those consultations. I hope you are getting it. And this collegium system has been criticized widely because of its opaqueness, opaque function, for the lack of representation and diversity, and for delay in clearing recommendation. So National Judicial Appointment Commission Bill came in 2015. In one or the other way, it gave wide representation in the appointment and the transfer of judges. If you see, it was a 6-member body which consists of the Chief Justice of India and 2 more judges, 2 eminent persons, 1 law minister. So 3 people and 3 people. These 3 came directly from judiciary. Law minister was the part of the executive. And these 2 eminent members, they were appointed by a committee which consists of the Chief Justice of India, the Prime Minister, and the leader of opposition. So in a way, if you see, the National Judicial Appointment Commission gave a very, very wide representation. Judiciary was the part of it, executive was the part of it, and the legislature was also the part of it. But it was declared null and void, it was struck down because in one or the other way it was infringing upon the separation power. It was infringing the basic structure of the Constitution of India, separation of power principle, and for that reason it was struck down by the Supreme Court. And now there are also debates going on around the country after the cash has been found, burnt cash has been found from the house of a High Court judge about the collegium system and the opaqueness of the collegium system. There is no transparency, there is no accountability, and this is one way where judges appoint judges. It does not happen anywhere. If you see the practice in some Western countries, in America or in Britain, they do have a more representative way of electing or nominating or appointing the judges. So some change is required, but in the word of the Chief Justice, the ex-Chief Justice of India, that it is not the perfect system, but it is better than many of the systems which were already existing. So let's see what happens in future. Moving on to the last topic, this is the Chief Justice of India, not the present Chief Justice of India, pitches for All India Judicial Services. Now, if you want All India Judicial Services now, Indian Administrative Services there, Police Services there, and if the government wants to add one more judicial service, what needs to be done? Simply the role of Rajya Sabha, the Council of State, comes here. Because in some or the other way it is going to infringe on the federal structure of the country, because this service will be there representing the union and the states both, and it is a matter which relates to the federalism. That is the reason why prominence is given to the Rajya Sabha. Rajya Sabha passes a resolution by 2/3 majority, by special majority, to empower the parliament to establish a All India service. Now this is the procedure which has to be followed. It is the Rajya Sabha which empowers the parliament to make All India services, to establish All India service. And if All India Judicial Service has to be established, it has to be established in this way, where under Article 312, Rajya Sabha passes a resolution.